My ladies, my lords, this appeal, as it relates to ICTA, concerns one main point of statutory interpretation: whether the Mauritian Parliament, in the Telecommunications Act 1988, intended to endow the regulator created under that Act, the Telecommunications Authority, with legal personality. In a nutshell, ICTA's submission is that the Court of Appeal engaged in an orthodox exercise of statutory interpretation and reached a conclusion that is inescapable when the relevant provisions of the Act are examined, namely that the legislator never intended the authority to have an independent legal personality, but rather that the authority would continue to operate as part of the government. There are essentially four main reasons for this, which emerge from an examination of the Telecommunications Act 1988 and a comparison with the equivalent provisions of the Telecommunications Act 1998 and the Information and Communication Technologies Act 2001. In my submissions, I will use the shorthand 1988 Act, 1998 Act, and 2001 Act. First, the authority under the 1988 Act was not established as a statutory corporation, unlike its successors, which were expressly endowed with legal personality under the 1998 Act and the 2001 Act. Secondly, the authority consisted of only 3 persons tasked with a limited range of functions, none of which required the authority to have legal personality, i.e., to be able to enter into contracts, to be able to own property, or to engage in civil litigation. Thirdly, the authority was not set up under the 1988 Act either administratively or financially to operate independently from government. Unlike its successors, it had no power to employ anyone or to run its own finances. Finally, and we say crucially, Parliament in the 1988 Act granted an immunity from civil claims in respect of the Authorities Acts to the government, not to the Telecommunications Authority itself. This, in our submission, is a clear indication that Parliament considered that the authority was part of government, not an independent legal entity. By way of contrast, under the 1998 and 2001 Acts, immunity was granted to the relevant authorities, the MTA and ICTA. The appellant's case does not engage with the proper construction of the 1988 Act. Rather, the appellant seeks to focus exclusively on transitional provisions in the 1998 Act and the 2001 Act. In summary, we submit that these provisions are not concerned with liability at all, but simply with ensuring continuity of administrative action between the authority and its successor. Furthermore, it is clear that the relevant savings provisions following the repeal of the 1988 Act could not and do not create any new liability that did not exist in the first place. In other words, if the Telecommunications Authority did not have legal personality under the 1988 Act, the repeal of that Act does not change the position as a matter of law. Finally, therefore, we have Emtel's argument on abuse of process. True it is that this claim took an inordinate amount of time to progress from issue in 2000 to trial in 2016. It also appears that the legal personality point was not run until the trial. but it was run at trial, it was adjudicated upon at trial, and it was further examined with great care and in detail by the Court of Appeal. Emtel has had every opportunity to argue its case on this issue. Furthermore, issues about legal personality are not, as Emtel's case states, procedural skirmishes. If we are right, Emtel has sued a defendant that has no legal personality, and the proceedings were a nullity ab initio. That is fatal to the claim, and indeed deprives the court of any ability to grant relief. In our submission, it is difficult to see in this context how it can be an abuse of the court's process for ICTA to make these arguments.
Can the proceedings be a nullity if the TA wasn't sued? It was ICTA sued. Why are the proceedings a nullity? The argument may be wrong, but why are the proceedings a nullity?
Well, if the entity which had legal responsibility under the 1988 Act is the Telecommunications Authority, which we say it is, and if it had no legal personality at the time, then you can't get round that difficulty by suing a successor which has not inherited the liabilities of that entity.
I can see that the argument may fail, but why are the proceedings a nullity?
Because you're effectively, the reality of the position is that although you're suing an entity that does have legal personality, you're suing that in respect of liabilities which arose in relation to an entity that didn't have legal personality at all. And in our submission, that those proceedings are a nullity for that reason.
Can you help me? You say that the TA under the 88 Act was an entity, was a non-entity that had legal responsibility. But I think your essential case is it was just a branch of government.
Indeed.
So why is, bearing in mind that the proceedings were originally against its first successor,
yes,
why is it not just a misdescription of government to call it the TA, when everybody understands what the responsibilities and liabilities are that are being referred to? And if it's just a branch of government, why didn't those liabilities transfer under the transitional provisions?
Well, I will come to that. I will come to that.
Go out your course, but
because
I
know. I mean, these are issues of statutory interpretation, and I propose to come to the relevant provisions. And if after those submissions, my Lord feels that that point still stands, I will certainly come back to it.
It's quite common in judicial review proceedings for the defendant to be a body that doesn't actually exist under that name. For example, government ministers. But nobody takes the point, and nobody would ever suggest that it made the proceedings a nullity.
Well, the position is, my Lord, that we accept that the Telecommunications Authority was a body consisting of 3 persons established under the Act, and we accept that it had public law powers, and we accept that it was amenable to judicial review. Those matters are not an issue at all, as I'm about to make clear in my comments. But the question of what one sees from the 1988 Act, which we're about to come to, is that the legislature intended that the government should enjoy immunity from suit in respect of civil claims. And that was a legislative choice that was made under the 1988 Act. And so it won't do to say, well, just because the Telecommunications Authority had public law powers and was amenable to judicial review, it must follow, as a matter of course, that it would have legal personality for the purpose of a civil claim, because those are, with respect, 2 very different questions. And the legislature has organised things in such a way under the 1988 Act that the government should not have liability to be sued for the acts of the Telecommunications Authority.
So the reason why the government isn't liable, and you can call it the Telecommunications Authority or call it the department, call it whatever you want in your proceedings, is not something to do with the government and Article 1382. It's because of the immunity.
Indeed.
If the immunity hadn't been there, they could have brought the action against the Telecommunications Authority. Someone might have said, actually, you'd be better off naming the government, and then they would have changed it and that would have gone on. But it really hangs on the immunity, and you say it's the government immunity, you can't get round that by calling it the TA.
Indeed,
Yeah.
indeed. And if this had been said, well, this is an entirely arid point, and all we have to do is amend, and we'll just include the government instead of referencing the TA, the difficulty they would have faced at the point of amendment was that there's an express immunity accorded to the government under the Act.
But you're presumably going to deal with the point that the transitional provisions require you to assume, contrary to the fact, that it was always the successor bodies that were running the show from 1988 onwards. I suppose you're going to say that, yes, but with the benefit of the 1988 Act immunity?
No, it's a bit more complicated than that. If I may come to it later, but essentially we say that the transitional provisions don't mean what Emtel says it they mean. Okay. They're actually doing something much narrower about conferring continuity of administrative action, not transferring liability. That will be my submission, but I will come to it shortly, my Lord.
The existence of the immunity, if TA was entitled to it, wouldn't render proceedings a nullity. Yes, a possible defence.
Yes, the nullity point arises from the legal personality point rather than the immunity point. I mean, if you are with me that the Telecommunications Authority has no legal personality under the Act, that's where the nullity point arises. The immunity point is a separate point, but it is related for the reasons that Lady Rose indicated, which is that potentially it would have been open to Emtel, it would have been open to the court or to Emtel at an earlier stage to say, well, actually, we'll just substitute the government, and that doesn't work because of the immunity.
If the point wasn't taken for 20 years and the court considered it was an abusive process to take it at such a late stage, the existence of the immunity wouldn't affect that.
Potentially, well, I'll come to my submission is that in relation to the arguments of abuse, the immunity is a relevant factor because you have to look at the totality of the situation. And if it was never the intention of Parliament that the government should be liable, or that indeed any regulator of the telecommunications sector in Mauritius should be liable for a civil claim, because there are equivalent provisions granting immunity under the 1998 and 2001 Acts. If that was the position, we say that is a relevant factor that the court would need to take into account on abuse argument. My ladies, my lords, just to say something a little bit about the factual background, which I hope is uncontentious before I go to look at the relevant statutory provisions. The judgment under appeal records that prior to the Telecommunications Act 1988, the regulatory functions of the authority were carried out by the government. The 1988 Act created a statutory regulator for the first time. That regulator was a public authority engaged in public functions and as such was amenable to judicial review, and of course extensive reference to Emtel's judicial review against the authority has been made in submissions on this appeal. After the judicial review had been brought, but before it had been finally determined by the Privy Council, Emtel commenced a civil claim for damages against the 4 respondents to this appeal. The issue before the Court of Appeal in relation to ICTA was simply this: was the legislative intent under the 1988 Act to endow the authority with legal personality, or was the authority still part of government? The question of legal personality concerns only the authority under the 1988 Act. The successor organisations, the MTA and ICTA, were established as statutory corporations, and it is common between the parties, everyone accepts that they have legal personality and may be sued in a civil claim for damages. But it is equally clear that the legislator did not intend that any of the regulators, TA, the MTA or ICTA, should be liable in a civil claim for damages, as they are each accorded immunity under their respective acts.
But they're not the same immunities. Well, the 88 Act immunities are not the same as the two later ones, which require good faith.
Indeed. They're not in identical terms. No. They're not in identical terms, but they are, but under the 88 Act, the authority is, the government is granted immunity, and under the 98 Act and the 2001 Act, the MTA and ICTA are granted a form of immunity, but as my Lord points out, there's a good faith requirement.
Well, so my understanding of the submissions yesterday was that according to Mauritian law, even though the 1988 Act immunity is not expressed to be subject to a good faith requirement, the underlying legal principles show that it always was, and that it doesn't apply if there's faute lourde or if there's intentionality. And that was then made express in the later legislation, but I may have got that.
I mean, we don't place any particular weight on the question of good faith and whether that's implicit under the 88 Act. All I'm saying, for the purpose of these submissions, and the relevance of it hopefully will become apparent, is that a form of immunity was accorded to the regulator under each of the successive acts. Now,
well, I would like you to clarify at some point whether you accept that the immunity conferred on the government by the 1988 Act was subject to the same caveat as the later acts.
Well, I will make sure that I do address that at the close of my submissions once I've taken instructions in relation to that. The next heading, my ladies, my lords, is legal personality. When it comes to determining whether a body created by statute has been endowed with legal personality, the terms of that statute are, of course, the main point of reference. And the legal principles governing that interpretive exercise are well established. The issue for the court is whether the legislature intended to endow the body in question with legal personality. Frequently, this is done with express words of incorporation, as we will see in due course with the MTA and ICTA. But express words are not always required. The court can, in some instances, infer the requisite legislative intent, applying the test laid down in the case of Conservators of the River Tone v. Act. And my lords, the judgment is at page 4834, please.
Sorry, 4?
4834.
Thank you.
I apologise, my lords. My electronic bundle is not carrying over to page 4834. Just bear with me.
But in very small print.
Well, you can.
Now it is. Thank you. So we have there the judgment of Mr. Justice Bailey, and what he says is, it is clear, halfway down that page, it is clear that a corporation may be created by Act of Parliament. The question, therefore, is whether it appears by the terms used in or the powers given to the Conservators of the River Tone by the Act of Parliament that it was the intention of the legislature that they should be a corporation. And that was an easy point to answer in this case, because absolutely everything, apart from express words, pointed to the fact that the Conservators were intended to have legal personality because they were entitled to take and receive gifts, they were entitled to hold land in succession, they were entitled to enter into contracts, they were entitled indeed to sue and be sued in their own name. So one could hardly think of a clearer case of intent to incorporate. And then, if we go down, please, to page 4836, we have the judgment of Mr. Justice Littledale. And he, at the bottom of that page, he says, to create a corporation by charter or act of parliament, it is not necessary that any particular form of words be used. It is sufficient if the intent to incorporate is evident. And then a little bit further below on the following page, he says, he refers to the case of Sutton Hospital and the words that were used in that case, express words. He says none of those words are contained in this Act of Parliament, and the question is whether the legislature has used any equivalent words which show a manifest intention to incorporate. And if we could briefly turn then to the Mayor of Salford case, please, which is page 4179. This is the judgment of Lord Esher, Master of the Rolls, and he poses the question here on at the start. The question in that case was whether, reading the statute, it could be seen by necessary implication that the legislature intended to make a certain body a corporation for certain purposes. That had not been done in express terms, but unless the implication was made, there was no remedy for infringements of the right given by the statute. And then, if we please go to page 4181, just 2 pages down, there's the judgment of Lord Justice Lindley, and halfway down the page there's a sentence starting, he refers to conservators of the River Tern and Ash. He says, in that case it was absolutely impossible, according to any principles of English law, to give effect to the Act unless the commissioners were held to be incorporated. Under those circumstances, it was held that incorporation was the necessary result of the statutory enactment. There is nothing of that sort here. And then at the bottom, final sentence, if you find that a body not incorporated can discharge all its duties and exercise all its rights without treating it as an incorporated body, you have no right to treat it as incorporated. So my ladies, my lords, we respectfully submit that the test is as follows. In the absence of express words of incorporation, the court must look at the terms used in the Act and the powers given to the body in question and ask itself, is it necessary to treat that body as incorporated in order to give effect to the Act? If the body in question can discharge all its duties and exercise all its rights without being incorporated, the court has no right to treat it as incorporated. With those words of introduction to the legal principles, which we submit were faithfully applied by the Court of Appeal, we'll turn to the Telecommunications Act itself, please, again, which is at page 3356. And one can see from...
This is the authorities you're giving us really from another age. Where government was very small and essentially consisted of a small number of civil servants and ministers. What struck me about the Act in the present case is that it goes to the trouble of establishing the TA, distinguishing between the TA, the minister, and the government, giving an express power to the minister to give directions to the TA. And one wonders why is this necessary if the TA is simply part of government? We live in an age of executive agencies, non-departmental public bodies, nationalised industries, and all the rest of it, which Lord Justice Lindley and Lord Esher obviously well from the one that they have.
Indeed. I mean, our submission in relation to that is that if you look at, as I am just about to do, if one looks at the 1988 Act and then compares it with the 1998 Act and the 2001 Act, there was a transformation in the telecommunications sector in Mauritius, and that under the First Act, the authority is very limited in scope and very limited in its powers, and that what happens later is effectively a transformation in terms of the role of the authority. And I will just, if I may, just go through the provisions, and then I think I can make that submission, my Lord. Firstly, on page 3356, we see that it's an act to set up a telecommunications authority. And then if we go down, please, to section 4, you can see that the authority is established, and it is a body that consists of 3 persons, a chairman, a representative of the minister, and a person with recognised experience in telecommunication. I would ask my lords to note there is no chief executive officer, there is no board, and there are no employees. That is what the authority consists of. And if we go down to the section 5, which deals with the functions of authority, which we've already looked at briefly, one can see that there are a limited range of regulatory functions, some more general, expressed in general terms, and some more specific. The more specific including issuing, modifying, or revoking licenses and sanctioning tariffs or charges. And then there are some slightly more general powers, but there are a limited range of functions, and none of those functions in our submission obviously make it necessary for the authority to have legal personality, i.e. to enter into contracts, to own property, or to be able to engage in civil litigation.
But it is established. It's established by law. That's the whole point of Section 4.
It is.
You don't need a statute to establish a government department. Government departments are established all the time without any legislative basis. You know, Department of the EU or Department for Culture, Media and Sport. So
Yeah.
the Prime Minister can...
We accept that this is establishing a body distinct from government in the sense that it is an entity tasked with specific functions, which is amenable to remedies in public law. We accept all of that, and we accept that it was the intention of the legislature to do that. But
establishing an entity which is amenable to remedies in public law.
Indeed, we fully accept that the authority was amenable to judicial review, and can be held to account for unlawful actions by the courts in that way. The question we're concerned with here is the liability of that authority for civil claims in damages.
You accept, I think, that it would be an indication favourable to an assumption of corporate personality if it needed to conduct civil litigation.
Yes.
Now, its functions include the control of radio communication services and facilities in Section 5(1)(a), and to do all such things as may be requisite under F. Suppose that a licensed communicator was using an illegal bit of bandwidth, for example, and surely why should the regulator not be able to go to court and get an injunction to stop them? That would be civil proceedings, wouldn't it? You wouldn't necessarily want to wait for the thing to wind its way through the criminal courts in the hope that a conviction would persuade them to behave better in the future.
Well, I will reflect further on that point and come back to it. But I think what we would say is that if you go through the acts and compare the powers of the authority here with the powers of its successors, which do have corporate personality and are unquestionably...
I understand that submission, but I'm asking you to apply directly the test which you invite us to apply, and to apply it in 1988 without, as it were, because this is all construction of what was done in 1988, where nobody had in mind that it would be supercharged in 1998, and ask whether the conduct of civil litigation would not be well and squarely within Section 5(1)(f).
Well, I think the question you have to ask yourself is not... the question is not so much, can one speculate a scenario whereby the authority might have to engage in civil litigation. And but really a question of whether under the Act, the intention of the legislature was that this body should have corporate personality.
Why is that the question?
Perhaps I can finish my submissions in relation to the three acts, and then we can come back to this point.
Well, before you do that, can I make my point in relation to the submission that you've just made?
Indeed.
Which seems to focus on a hard and fast distinction between judicial review proceedings and civil proceedings. But underlying both are public duties.
Indeed.
And both in English law and we know in Mauritian law, you can have liability of a public authority civilly for the way in which they exercise their public law powers. In English law, it would be misfeasance in public office. In Mauritian law, we see if there's folklore in relation to the exercise of public powers. So how can you maintain such a hard and fast distinction in relation to proceedings which may be brought against the authority, so as to exclude the potential for liability and damages for the way in which they carried on their public law functions?
Well, we say that here it was the intention of the legislature that the Telecommunications Authority should not be so liable.
But why? They've got public powers, we see them, Section 5 and so on, so that the primary intention is behave like a public body.
Yes.
Now, if it's part of general law that public bodies that misexercise their powers in serious ways are civilly liable, why isn't it the intention of Parliament that they should be civilly liable like any other public authority?
Well, we deal with this in paragraph 53 of our written case, where we draw attention to the jurisdiction of the King's Bench Division and how it has evolved over time, and the incredibly broad powers of the King's Bench Division in terms of controlling inferior courts and tribunals and people exercising public functions, with the position at common law in relation to the liability of the state, where historically, and this is the Chagos Islanders case and the quote from Lord Justice Sedley, which we've set out in our written case, historically the position is that the state is not liable at common law, and it's only as a result of the Crown Proceedings Act creating liability where individual servants of the Crown are liable, then in some circumstances the Crown can become liable. That's the basis on which liability is created. So in our submission, the English law has always treated differently those questions.
Forgive me for interrupting, but we're dealing with Mauritian law, quite apart from English law, which what you say sounds quite contestable to me. But I think I'm right in saying that Mauritius has a constitution, doesn't it?
Yes. And
that you can have damages for breach of your constitutional rights by a public authority.
Yes.
So could the TA not have breached people's constitutional rights? And if it could breach people's constitutional rights, why couldn't it be sued for breach of their constitutional rights?
Well, I mean, you're asking me to advance a case that has never been to address a case that has never been advanced. I mean, this isn't a case that is brought against. No,
I appreciate that. The only reason I'm raising it is to test the viability of your proposition that there's a hard and fast distinction between capacity to be sued in public law, and you accept they can be sued in public law, and capacity to be sued for damages civilly.
Yes, I mean that distinct.
Riley and Mackman wasn't positing such a rigid categorisation.
No, I mean we accept that there are many situations in which public bodies can, of course, become liable for claims and damages, but invariably either that's because there's a constitution conferring a right of that kind, or because there's been a legislative intervention that allows that, such as the Human Rights Act, for example.
No, forgive me, but that is not the case. In English law, the common law creates the tort of misfeasance in public office, nothing to do with statute.
And there are certain exceptions of which that's true, and misfeasance is one of them. But as a matter of generality, the submission that the treatment of public authorities under public law is very different from the liability to a civil claim of those public authorities. That's the submission that we're making, and respectfully, that submission is well founded. We submit.
Yes, thank you.
If I may return to the 1988 Act, please. If we, as we go through, there are no powers in the 1988 Act for the authority to employ its own staff or to raise money for its own operations, for example, through levies on licensees. And the authority has no administrative or financial independence. If we look at page 3369, please, we have section 29. We have section 29, which provides that no immunity shall attach to the government in respect of any
liability.
Sorry, no liability. Immunity of government. Apologies, my lady. No immunity, no liability shall attach to the government in respect of any action, claim, or demand by any person in consequence of any damage arising from anything done or omitted to be done by a licensee.
That doesn't give the government immunity from something it has done wrong.
Well, but the nature of the nature of the nature of this, the way this case is put is that the licensee Cellplus was effectively was in breach of its license and was allowed to do things that were in breach of its license, and that was. And that the Telecommunications Authority allowed that to happen. I appreciate that, sir. In this case. So yes. But we're trying to construe this Act to see whether it's conferring corporate identity on the authority. Yeah. And if you look right through the Act, all the things that the authority can do, the things that the government can do under the Act, this is actually a very narrow, small immunity. It's effectively saying you're not vicariously liable for something done by a licensee. But it doesn't confer any immunity on all the other, on the consequences of the misperformance of all the other functions in the Act, does it?
So, just to take an example, to put some flesh on the bones, if I may, of that. Suppose that there was a refusal to grant a licence when one should have been granted, in circumstances which in English law would amount to misfeasance in public office, might in Mauritian law amount to a breach of constitutional rights or folklore. There wouldn't be immunity in respect of that under this, would there?
Well, in my submission, the ability to hold the authority, i.e., in this context, the government, to account through public law would give you rights and remedies in relation to the sorts of examples that you're giving.
I think that's to answer my question. No, this immunity would not apply in such cases.
That's right, but we accept that we're not contending that this is an immunity for all purposes. It is our submission that the authority can be held to account for unlawful acts in relation by way of public law. What we're addressing here is action, claims or demands. It's claims for damages. It's claims for damages in relation to unlawful actions arising from what's been done by people who've been licensed.
So not by the authority itself. So a claim for damages in relation to the authority's behaviour does not attract this immunity.
This provision is intended to address the liability. We submit that this provision is intended to accord immunity from civil suit to the government in relation to the conduct of licensees that are being regulated by the authority.
So I think your answer to my question is yes, it's not intended to cover that sort of immunity.
I'm trying to picture the scenario my lady's envisaging.
Well, as my lord put to you,
yes.
If the authority refused for discriminatory or capricious reasons to grant a license to a licensee, to a potential licensee.
Yes, indeed.
This immunity would not would not cover a claim for damages for that behaviour.
That must be right. That must be right.
But then I think one... Oh, sorry.
No, I thought that your case was that this is an immunity attaching to government. And I think you say that because the Telecoms Authority is not a separate body but is in fact government,
yes,
you can't get round this immunity insofar as it applies by suing the TA instead of suing the government.
indeed.
So whatever conduct is or isn't covered by this immunity, when that conduct is by those three people listed,
Yes.
that is treated as conduct of the government for the purposes of this immunity.
That is my submission.
Right. And then as far as whether it's done by a licensee or not, I thought your case was, well, here what they're complaining about is the conduct of Cell Plus and MT.
Indeed.
Any conduct by a licensee can be re-expressed as failure of the TA stroke government to stop it from doing that.
Indeed.
So,
As it is in this case.
yes, and there may well be cases where it's nothing to do with the licensee, as has been posited, where there's a refusal for unfair reasons to grant a license. But that case is not this case.
That's right, my lady. That is right. Now, so we place reliance on section 29 because in our submission it's clear from that provision that the legislature was proceeding from the premise that the government would be liable, not the authority itself, hence the need to give immunity to the government. Now, yesterday, my lord, the court had questions about section 9, the minister's power to give directions, and section 13, the right to apply to a minister for a review. We respectfully consider that those provisions do not assist either party's arguments on legal personality. They are essentially neutral, and I don't rely upon those provisions for the purpose of my submissions. If necessary, I can develop that point later, but I'm conscious that I've got a lot of ground to cover, and I will come to it if that's a point that is exercising the court. If we could please now look at the 1998 Act, which is at 3379. And again, we have the title to the Act on page 3380, to provide for the establishment and management of a Mauritius Telecommunications Authority. And then section 4 is once on page 3384 is once again the provision that establishes the authority. And one can see here from section 4.1 that it is expressly stated which shall be a body corporate. So the legislature has in this instance decided to endow the MTA with corporate personality.
Are we allowed to look at an act passed 10 years later to construe the earlier one?
No. Well,
because here we're really on the construction of the earlier act, aren't we?
Mm-hmm. Well,
so even so far as there's an alternative route which the appellants rely upon, which is the effect of the transitional.
Well, we submit that in relation to that, this is part of the context which helps make sense of what's going on under the 88 Act, is what's happening under the 1998 and the 2001 Acts. Now,
there's a lot of authority on this, and you'll find that an Act 10 years later can't be used as an aid to interpretation of an Act 10 years earlier.
I mean, it's we don't rely on it as saying this means that you construe the provisions of the 1988 Act in a particular way, but we do rely on it for the purpose of saying, look at the differences, and the differences are significant, and the differences help one understand what's going on in 1988. That's what we're seeking to do. So it is contextual. It's not directly interpretive. We're not saying read the provisions of the earlier Act differently because of what happened later.
I mean, in a sense, this Section 4.1 just tells us that Parliament can legislate expressly to make something clear, but you've introduced us the authorities that show that it can do so
Indeed.
by implication. And the question for the 88 Act is whether they did it by implication.
Indeed. So I'm not going to dwell on it, but I'm going to, if I may, just draw attention to the differences, please. Firstly, it's expressly established as a body corporate. Secondly, there is a board under this Act, which has a chairman and 4 other members. If we then look at Section 5, under this Act, the MTA has an executive director who's the chief executive officer, and the authority is empowered to take on employees under Section 5.2a.
How do we get assistance even from these contextual points from this later statute? You've already made the point about employees and so on. How does it help us on construing the 1988 Act to find out that an authority established in 1998 had power to employ people?
Well, if we then go, please, to Section 6, which is the functions of the authority, one can see that under this Act, the authority had a much, much wider range of functions than the Telecommunications Authority under the 88 Act. And you can see at Section 6.1a through to S, the very wide range of functions that are now bestowed on the authority, including expressly in terms of the regulation of competition and so forth. If we then go, please, to Section 7, one can see here that there are financial provisions which enable this authority to derive income from fees, charges and fees, and that income accrues to the authority itself. Again, to be contrasted with the position under the 1988 Act, where the income raised went into essentially central government funds. If we then please go down to Section please bear with me, page.
Can I just ask you?
Sorry.
Something we certainly can look at as part of the context is the Transfer Act of 1988.
Yes.
Are you going to come to that?
Yes, I certainly am. I certainly am. And then, please, on page 3403, we've got a provision in relation to the extent of liability. And here it says, no liability, civil or criminal, shall attach to the authority or to any member or officer in respect of any loss or damage arising from the exercise in good faith by the authority or by a member or officer of its or his functions under this Act. So, again, by way of contrast to the 1988 Act, where the immunity is expressly conferred on the government, under the 1998 Act, it's conferred on the authority itself. And then substantially the same position is reached in relation to the 2001 Act, and that's page 3267, please. The 2001 Act We see from page 3270, it's an act to establish the Information and Communications Technology Authority. We see in relation to section 4, which appears at 3384, please. 3278, sorry. That again, it's established expressly as a body corporate. We see from section 5 on 3279 that it is, there is again a board, this time with a larger number of people on it. We then, going down to section 14 on 3283, again, there's an executive director who is the chief executive of the authority. Section 15 again provides for the employment of staff. And section 18 defines the functions of the authority. And again, one can see that the functions of the authority here are, again, far wider and more extensive than the functions of the Telecommunications Authority under the 88 Act. We have to go all the way through to page 3289 for those functions to be set out. And then if we look at section 20, you've got a whole series of provisions relating to the funding of the authority, and essentially that the authority can be partly self-financing, and so that it receives monies from the fees and charges that it levies. And then if we go, please, to page 3403, we've got section 22, again, in terms we've seen, no liability, civil or criminal, shall attach to the authority or to any member or officer in respect of any loss or damage arising from the exercise in good faith by the authority or by a member or officer of its or his functions under the Act.
Which section is that? 51.
Sorry, I apologise, my lady.
That's the other Act. Yeah. That's the earlier Act.
I'm so sorry. It is page 3319. Okay. It's section 45. I do apologise. Now, what these provisions highlight in our submission is that the authority in its original guise was not set up as a statutory corporation, unlike its successors. It was charged with a limited range of functions that in our submission do not by necessary implication mean that it had to have had legal personality. It consisted of only 3 people, with no board, no CEO, and no employees, and it was not empowered to run its own finances. Indeed, as recorded in the Court of Appeal's judgment, the fees levied by the authority went to central government. And in our submission, the authority didn't need its own employees or its own finances because it had the support of civil servants and central funds.
That perhaps is a neutral factor. The courts don't have their own staff either. Their administration is provided by government.
Yes, but it's not contended that the courts have legal personality for the purpose of a civil claim in damages. And the question here is whether looking at the 1988 Act, in the absence of express words of incorporation, one can, by necessary implication, find that it was intended that it should be a corporate body.
Well, can I take you to section 9?
Yes, indeed.
That's on page 3359. You'll see
yes.
the minister may give to the authority such directions, the authority and the council, such directions as to the performance of their respective duties under this Act as appear to the Minister to be requisite in the public interest.
Yeah.
Okay. And the authority in the council, as the case may be, shall comply with such directions.
Yeah.
One might wonder why that provision is necessary at all if the authority is simply part of government. But be that as it may, it's seemingly placed under a statutory duty to comply with ministerial directions.
Indeed.
Which one, again, might have thought indicated it was some sort of legal entity. If you go on to subsection 2, we're told there that the minister may exempt any department or unit of government from the necessity to comply with this Act. Now, I presume on your approach, under subsection 2, he can exempt the TA from the necessity to comply with the Act. Is that right?
Yes.
Yes.
Indeed.
Yeah. So we have quite elaborate provisions about the authority in the council in subsection 1, but you say they fall within, they are simply departments or units of the government within the meaning of subsection 2.
Yes, I mean, we've sought to, if one tries to compare, so looking, I'm conscious that I'm now going to be referring to the later acts, but it's interesting to see the way in which these powers, if you look at the way in which these powers come in and out of the legislation, there isn't a consistent picture which points towards one answer or the other in terms of legal personality, because under the 1998 Act, there is no equivalent power of the minister to give directions to the MTA. But under the 2001 Act, there is an equivalent, albeit a slightly different power to give directions, and that's in section 19. The page reference is 3290. And again, we also had a look at the question of appeals and whether there was significance of the fact.
That's another aspect of it. I mean, why would you give the existence of a right of appeal suggests they're two different bodies?
One might have.
I mean, one has internal reviews sometimes of a departmental decision by a minister, but one wouldn't have an appeal from the department to the minister because the minister is, we're talking, in Carltona would apply, the department, simply the minister acting through his officials.
Yes, well, the position, it does appear that it would be it is a review under the 1988 Act, under section 9 of the 1988 Act.
I think it's section 13.
Section 13. Yeah.
Any applicant or licensee who's dissatisfied with the decision of the authority may apply to the minister for a review of the decision.
Yeah, so it is a review. It is a review there. And then what happens under the 1998 Act is under page 3402, you've got appeals to the minister under the 1998 Act, not a review. And then
I'm not sure that one should get too hung up upon review or appeal. I mean, the title to Section 13 is appeal from decision of the authority. And all that Section 13 says is the minister can make such orders as he thinks fit, which is what happens when you get a pure appeal.
Indeed, I'm not placing particular weight on that wording. If we then look at what happens under the 2001 Act, there is effectively a tribunal established under the 2001 Act, it's page 3313, where the section 30, where there's effectively an independent tribunal. But in our submission, I readily accept that it may seem to be slightly surprising that if the authority remains part of government, that you have these provisions for a review by a minister and the power of the minister to give directions.
And also a requirement in Section 22 makes certain powers of the authority only exercisable with the approval of the minister. I mean, it seems, you know, if it's simply a government department, everything it does is done on behalf of the responsible minister. There would be no need, it would be extraordinary to have a statutory provision requiring it to obtain the approval of a minister before taking certain decisions.
In my submission, none of these provisions are. I mean, I can accept that there are provisions that potentially point towards different outcomes, and I can accept that there are provisions which may seem to be OTOs to an extent if the analysis that this form part of government is correct. But the legislator has. May have, but the real question is whether by necessary implication, looking at the powers given to the body under the Act, whether it has to be a body corporate in order to discharge those functions. And in our submission, it doesn't.
I still don't really see why that's the real question, as you put it. I think the real question is, regardless of whether it was the Telecoms Authority or the government that they would have sued if they'd done this before 1998, or if that Act hadn't come in, what happened to that liability of the government? First of all, did that liability exist, or was it covered by the immunity? And assuming it wasn't, where does that liability lie now? And in particular, was it transferred to the MTA by the transitional provisions? Isn't that the real question?
Well, I'm grateful that my lady has sort of refocused the submissions on that point, because I'm going to come next to how the Court of Appeal dealt with these points in its judgment, and then look at the transitional provisions in some detail and what we say in relation to those.
You did say you would look at the Transfer Act provisions.
Yes, I will also look at the Transfer Act. I will. First of all, so in our submission, if you look at the powers accorded to the authority under the 1988 Act, and the fact that the immunity under the 1988 Act is for the government, there's an indication there that the legislator regarded the government, not the authority, as the legally responsible entity under the Act. And the only civil claim that we are aware of that relates to the authority was a contractual claim brought by a former controller of the authority, and that claim was brought against the government. And that case is Ankia versus Government of Mauritius, and it's at page 3419. There is also one piece of contemporaneous documentary evidence that the Court of Appeal refers to in its judgment that supports the view that the authority was part of government, and it's at page 1661. And it's a letter dated 24th of April 1990, and the slightly confusing aspect is the nomenclature is here referring to the MTA.
This isn't a public document.
Sorry?
This isn't a public document, is it? This is a letter of...
This is a letter to Emtel from the financial secretary.
Well, you know, there's a very strong statement in one of Welsh devolution judgments, the first no, the second Welsh devolution case, where Lord Thomas and I co-authored the judgment about the impermissibility of looking at correspondence between officials, or officials and companies in this case, as an aid to the interpretation of legislation, because they're not publicly available.
Very well, my lord. I won't press the point any further. We don't need to place any particular reliance on this letter. If we could please go to the Court of Appeal judgment at
If I'm wrong about that, do come back.
Well,
the case I'm thinking of is the one about agricultural workers and the abolition of the boards that fixed their wages, and it's in it's when Lord Thomas was Lord Chief Justice.
Yeah, I think there's also a statement by Lord Diplock in Fothergill and Monacair lines, which is very much along the same lines.
Very well. I'm not, given the shortage of time, I'm certainly not going to detain your lordships further with that point. If we could please go to the Court of Appeal's judgment at page 2804. Where it deals with the question of legal personality. It points out that in Mauritius, statutory corporations are created by an Act of Parliament, and it says that it's Section 2 of the Interpretation and General Clauses Act, a statutory corporation means a body incorporated by an Act. It refers to the TA as having been established by Section 4 and then sets it out. It then points out that the TA was not established as a body corporate, and then on page 2805, it points out that there's been a consistent practice in Mauritius that where it was intended that a body should be a body corporate, it has been created as a statutory corporation, and it identifies 13 acts in the period 1987 to 1989 where various bodies created under those acts, councils, commissions, boards, trusts, funds and institutes, shall be a body corporate, and then says it has been the invariable practice of the Mauritian legislator to use clear and express terms to indicate the creation of a statutory body as a statutory corporation, the attributes of which are set out in section 37 of the IGCA, and which can sue and be sued in its own name. On the other hand, where there's been no intention to create a distinct statutory corporation, but a statutory body within the executive framework of government, it has not been incorporated as a body corporate in the creating statute, and it gives the example of the Revenue Authority in that context. At the bottom of page 286, the judgment refers to the Statutory Bodies, Accounts and Audits Act and points out that where bodies have been established as statutory corporations, they are listed in a schedule to that Act, and they have a number of statutory duties and obligations which are then set out on page 2807. And the court points out that the Telecommunications Authority was never listed as a statutory body in the schedule to the Act. And it says the need to comply with the above statutory duties and obligations with regard to financial management and accountability, which would apply to a statutory body with a distinct legal personality acting independently of government financial control, did not obviously arise in the case of the TA. Both the administrative and financial structure of the TA, as established under the 1988 Act, strongly indicate that it was to all intents and purposes operating as a government department.
Can you give us a date for the Statutory Bodies, Accounts and Audit Act?
I will, my
I
lord.
just want to know whether it's 1988 earlier or later.
I will.
But I mean, conceptually, it seems to be perfectly possible for the TA, for accounting purposes, to be incorporated into the government's accounting system with accounting officers and so on, whilst also having legal personality for present the sorts of purposes that we're talking about at the moment. Indeed, it seems to me very likely that that was the case. So the exclusion from the Statutory Bodies, Accounts and Audit Act would not be so surprising then, because the TA's accounts would be dealt with essentially like a government department, and so one wouldn't expect it to be listed. But that doesn't answer the question whether or not it has legal personality for the purposes of being sued in a civil claim.
I would agree with that, my lord, but I think the point that the Court of Appeal is making is a slightly different one, which is that where in Mauritius it has been intended that a body should be endowed with legal personality, it has invariably been created as a statutory corporation by express words in the Act, which is, of course, what we see under the 1998 Act and the 2001 Act. And the year of the Statutory Bodies Accounts and Audits Act, my Lord Briggs, is 1972. 1972, yeah. And then what the Court of Appeal does is it does effectively a functional analysis looking at the functions of the Telecommunications Authority under the 1988 Act. And it says it has been seen that it was not the intention, this is page 2808, it was not the intention of the legislator to create the TA as a body corporate whenever it has been the intention to create a statutory corporation which is endowed with a distinct legal personality. He has done so by using express terms which leave no doubt as to the fact that it has been incorporated as a statutory corporation as contemplated by Section 2 of the IGCA.
Well, this is going well beyond Lord Isha and Lord Justice Lindley. I mean, effectively, we're being told it's inconceivable that there could be a body corporate created by statutory implication.
No, because what the court then goes on to do is it goes on to look at the necessary implication point and looking at the functions of the authority. Right. And it says not only is the legislator refrained from incorporating, but the scheme of the legislation does not also confer on the TA the attributes associated with the operation of a statutory body with a distinct and independent personality of its own in respect of civil proceedings in tort. On the contrary, it bears the characteristics of a body operating as an integral part of the executive arm of government. And then you can see at 1 through to 5 the factors that the court relies on. And we've addressed those in relation to administratively. The TA has no board of administration. It consisted only of a chairman and 2 other people. It's only a 3-member authority that doesn't have provision in relation to having staff and being able to take on employees. There's no provisions in the Act with regard to the financial administration of the authority, which confirmed that it was meant to operate as a government department, and in particular there is no provision for funding of its expenses, and any income such as licence fees under section 21(2) would go into the consolidated fund through the ministry. And then it points out the differences between the position under the 88 Act and the later Act in relation to those matters of financial administration. And then it deals with the Section 29 immunity from liability pointing out that the immunity under the 88 Act is accorded to the government and not the TA. And says
that would be immunity that would otherwise arise potentially under 1382.
Indeed. And so the court then concludes, it is abundantly plain, therefore, that at the material time, the TA did not have the functional characteristics of a body with a distinct legal personality of its own against which civil proceedings in tort could be entered. It was to all intents and purposes operating as a government department and not as a distinct legal entity. It had neither the status of a statutory corporation nor the attributes of a personality juridique operating on its own, and which was lawfully empowered to sue or be sued in its own capacity in respect of civil proceedings in tort. So that is the central reasoning of the Court of Appeal. And in our respectful submission, the Court of Appeal has faithfully applied the principles of statutory interpretation established by the conservators of the River Tone case, looking carefully at the relevant legislation, particularly the 1988 Act, and the powers given to the authority.
Can I just ask for a bundle reference for the Statutory Bodies Accounts and Audit Act? Can you help us with that?
Yes, indeed.
Or someone could give it to us at some point.
I don't think it is actually in the bundle. I'm getting shaking heads around, but I can...
In that case, could we ask for it to be supplied?
We will supply that electronically after the hearing Monday.
I do wonder whether the Court of Appeals made perhaps a bit too much of this separate accounting point. You accept that the TA could have been sued in judicial review proceedings. It doesn't have funds of its own, so who's going to pay for its legal representation? Obviously, we would have to go to the government and say, please give us the money so that we can pay our lawyers. So the same would be true if it were sued, if it were possible for it to be sued in civil proceedings for damages. It doesn't have any money of its own, but in the same way, it would go to the government and ask for the government to fund it so that it could pay those damages, just as the government would fund it to pay the legal costs in the first example.
Yes, but I mean, in my submission, the court was actually doing something different there. It wasn't just saying it doesn't have its own finances. What it was saying was that in Mauritius, where it has been intended to endow a body with legal personality, it's been created as a statutory corporation. And then once it's a statutory corporation, there's a specific regime which then applies to statutory corporations in terms of their accountability for their finances and so forth, which is necessary precisely because they're not part of government. So that's the way the point comes in, my lord.
Yes, thank you.
Can I mention if Mr. Chu Choi is to have his 15 minutes,
he is,
then you need to wind up in a couple of minutes.
No, he's very kindly said he won't need his 15 minutes and he can manage with 5. And the appellants have said they can manage with 25. So I have another 15 minutes.
And we still need the all-important transitional provision.
I'm coming to those in one moment. So. But the point about immunity from suit goes further, we submit, than was recognised by the Court of Appeal. Because if the appellant is right that the authority does have legal personality and is the right defendant to this claim, then in our submission that thwarts the statutory scheme because it undermines the immunity from suit that Parliament intended that the legally responsible entity, the government, should enjoy under Section 29. So on Emtel's case, we would have an outcome whereby, even though the legislature clearly intended that the regulator of the telecommunications sector in Mauritius would enjoy immunity from suit under the 1988 Act and 2 subsequent acts of Parliament, that attempt has failed under the 88 Act, and there is effectively a loophole that allows the appellant to bring a civil claim that robs the regulator of that protection. And in our submission, Emtel's case is seeking the opposite outcome to what the legislator actually intended. My lords, coming to the transitional provisions point, Emtel's case is that the Court of Appeal was wrong to decide whether the authority had legal personality under the 1988 Act. All you have to do is look at the transitional provisions in the later acts and they give you the answer. We submit that that argument is wrong for 3 main reasons. First, it's an erroneous approach to statutory interpretation, as it simply ignores the relevant provisions of the 1988 Act. The 1988 Act has to be, in our submission, the main point of reference for deciding the legal status of a body established by that Act. And in our submission, that approach also ignores the instructive comparison between the 1988 Act's provisions and those of the 1998 and 2001 Acts. And Emtel's case doesn't really engage with the legislative provisions that are in the 88 Act at all. Secondly, my lords, we submit that Emtel's argument misunderstands the nature of the transitional provisions in question. And if we look at, please, page 3407.
3407.
Yeah. We've got section 29 of the 1998 Act. And this refers to every act done by or in relation to the Telecommunication Authority established under Section 4 of the 88 Act shall be deemed to have been done or commenced as the case may be by or relation to the authority. Now, we submit that this is a provision which is about preserving the continuity of action of the authority in the period of transition to its successor. And absent such a provision of this kind, it would be necessary for the successor authority on day one to reinstitute all of the regulatory arrangements of its predecessor, for example, licenses issued or charges levied on licensees. And the consequence of this provision is that those acts by the authority remain valid when the successor authority takes over. And that's supported in our submission by section 29(2), which is a provision which makes it clear that licence holders 3 months after the commencement of the Act have to inform the authority in writing about that and surrender their licences. And that the granting of a licence is an example of an act done by the Telecommunications Authority that is deemed to have been done by its successor, but then for which specific arrangements are made under subsection 2. So in our submission, the focus in section 29 and in section 51 of the 2001 Act is on acts of the predecessor authority being deemed to be acts of the successor. It isn't concerned with the liabilities of the authority or its successor at all.
How do you draw that distinction, though? I mean, suppose we're dealing with a licence that was, as we were discussing earlier, a licence that was granted to somebody in breach of an undertaking that had been given, or a promise that had been given by the earlier authority not to licence anyone because it was granting an exclusive period. So which bits of that situation carry forward? The licence to the new market entrant, you say, carries forward, but what about the accrued cause of action against the authority for breach of the legitimate expectation that was raised, or even breach of Article 1382? I don't know how you splice up.
Well, may I just draw a contrast with the position under the in relation to the under the 2001 Act, because one can see the two provisions together there, which make it clear what the. And then I can come back to my lady's point. If we go to page 6078, please, one can see that there is. Sorry, 6076. So this is now in the 2001 Act. We've gone to later in the bundle because the original version of the Act was the Act as amended, and these are the provisions which were subsequently repealed, but applied at the relevant time. And what you can see there is there's an express provision there, section 23, which transfers the assets, interests, right, privileges, liabilities and obligations of the MTA to its successor, to ICTA. Now that's the kind of provision which is actually really concerned with carrying over liabilities from one body to another. And the reason, before my lord jumps in, and the reason why why that's necessary here is because the MTA is being brought to an end as an independent legal personality, and the ICTA is to be its successor, and so the liabilities are carried over expressly from one to the other. In our submission in relation to the authority, the position is different, because if we're right that the authority is part of government, a government will continue post the repeal of the 1988 Act, and any valid claim that you had against the government under the 1988 Act, you would continue to have, notwithstanding that the Act had been repealed. So it isn't necessary to have this kind of transfer of liability provision. And that's why I'm coming back to my lady's point. And therefore, one can see, if one goes just a couple of pages on to page 6078, we've got section 51, which is the equivalent of Section 29 of the 1998 Act, transitional provisions, and you can see there every act done by or in relation to, it's the same wording, and you can see that again there's provision specifically with regard to licenses. And in our submission, the fact that these two provisions exist alongside one another in this Act demonstrates that every act done by or in relation to is to be read in a relatively narrow way, that this is concerned with continuity of administrative action and not with liability. That's the point.
So my question was going to be, I think, showing the puzzlement of my lady, how one can draw a line between transfer of acts and transfer of liabilities, because liabilities may be consequent upon acts. So if the acts have transferred in circumstances where they would carry a liability with them, why does the liability not get carried over?
Well, the liability is the question. The question for these purposes is what is the legislature seeking to do in Section 29, and what is the legislature seeking to do in Section 51? And in our submission, Section 29 is not addressed to the question of liabilities in that broad sense. It is talking about administrative acts, and you can. And
you say that, but we're asking you how administrative acts are what give rise to liability.
Indeed, and where there is a liability under the 1988 Act that the government has, that will carry over. That remains the case even when the 1988 Act has been repealed. So there's no need for.
So it won't carry over, in effect.
It won't in a sense carry over to its successor, yeah, but you'll still be able to bring a claim against the government.
And why would the government want to do that?
Well, if the position is that correctly analysed, the government is the legally responsible entity, then that is simply consistent with the Interpretation and General Clauses Act, which the Court of Appeal refers to in its judgment, which is the equivalent of our Interpretation Act, which has the effect that the repeal of a statute doesn't have the consequence that acts done at the relevant time don't continue to incur liability in the way that they would have done at the original time. And that's dealt with in the Court of Appeal's judgment at page 2803, and it's referring back to section 17 of the IGCA, which is in the bundle at 3345. And that we can see there, section 17, and I'm just going to draw my Lord's attention to it. I'm going to give my Lords the reference to the Court of Appeal judgment. The passage is on page 2804, where it explains that absent any specific statutory provisions, the position is governed by the general law in the IGCA, and that the consequence of that is that if the TA was not liable under the 1998 Act, no new liability could arise, but if it would have been liable under the 1988 Act, that liability would continue to exist. So that's how the Court of Appeal approached it, by reference to the general law and the effect of the repeals under the general law. I'm going to deal with the Transfer Act point because that is very much of concern to my Lords, and then I will wrap up now as quickly as I possibly can.
But you are going to deal with the point about the scope of the immunity in the different acts.
Yes.
A short point, but it may be an important one.
Yes. So first of all, on that short point, do we accept that the immunity under the 1980 Act was subject to a requirement of good faith, my lady had asked, or maybe perhaps I think it was my lady had asked. Yes, we do accept that, that the scope is limited to good faith conduct. There may be dispute as to the scope of the principle, but that's obviously not a matter that we would make submissions on to the board at this point, but we do accept that submission of Emtel. In relation to the Transfer Act point 3377, this point wasn't raised before the Court of Appeal, and hence it's not dealt with in its judgment. And when we first looked at section 32B, which is on page 3378, we did ask ourselves what could be meant here by the rights and liabilities vested in the TA. And in our submission, it's instructive to look at the whole Act. But if the effect of section 3 is that the undertaking of the government relating to the department shall, on the appointed day, vest in the licensee, which is the Mauritius Telecommunication Services Limited. And if we go then down to subsection 5, we can see that any contract entered into by the government for the department is then transferred to the licensee. So that's the company. And under section 4, any action, arbitration, proceedings or cause of action which immediately before the appointed day is pending in favour of the department or to which the department of is a party may be continued and enforced against or in favour of the licensee. And then if we go back to section 3.2a, you can see that the property assets of the department are transferred to the licensee too. In other words, all of those things that require legal personality, holding property, entering into contracts, engaging in litigation, they're all transferred from the department to the company and not to the authority under this Act. So then that begs the question, well, what is left of rights and liabilities of the Telecommunications Authority under section 3.2b? And in our submission, it can only be a reference to public law rights and liabilities. Because effectively...
I thought that before this, the department both was the regulator and, insofar as there needed to be regulation, and operated the fixed network.
That's right.
Right, so this is to split those two things, operating the network and regulating the telecom sector.
Yes.
Okay? So this is dealing with that part of the department that now is going to be run by the company that's operating the network.
Correct.
Right, which is not got to be the same as the regulator. That's the point of the exercise.
Indeed, indeed.
Right. So then the question is, okay, so clearly from this, all those rights and liabilities that belong to the department that relate to the operation of the network go to the company. What happens to all those rights and liabilities of that part of the department that used to be the regulatory body? Do they stay with the department or do they vest in the Telecommunications Authority? And 3.2b seems to suggest that they vest in the Telecommunications Authority.
Yes, but if one then looks at, I would accept that, but then the question is, what rights and liabilities are we talking about here? Because all of the rights and liabilities relating to civil claims are expressly being transferred to the company under Section 4. Any action, arbitration proceedings or cause of action, which immediately before the appointed day is in favour of the department or to which the department is a party, may be continued and enforced against or in favour of the licensee. So in our submission, if you read this Act as a whole, all of the property goes to the company, all of the civil liability goes to the company, all of the contracts go to the company.
But there must only be those that relate to operating the network. The poor company operating the network can't now be saddled with all the rights and liabilities of the whole department, which may have done all sorts of other things.
Well, I mean, if one looks at what this Act appears to be seeking to achieve, what it appears to be seeking to achieve is that that all of those matters are transferred to the company, and then we have to ask ourselves, well, other than the rights and liabilities which are vested in the Telecommunication Authority, what do the rights and liabilities vested in the Telecommunications Authority mean? And they can't, we respectfully submit, mean rights and liabilities in contract, rights and liabilities in relation to civil claims, because those are expressly dealt with elsewhere in the Act, and those vest in the company. So it can't mean that. So what is left at that point of rights and liabilities? And we consider that must be rights and liabilities as a regulator in public law.
But as we discussed before, liabilities as a regulator can exist in civil law. Are you saying somehow they don't go under this regime, those liabilities don't go to the Telecommunication Authority, but go to the company? That would seem to be bizarre.
Well, the rights and liabilities in relation to civil law concerning civil claims for damages, this is talking about actions, proceedings, or causes of action. We're talking here about mainstream civil claims. Those liabilities by Section 4 become the liabilities of the company.
But I'm asking you about whether you would call them mainstream or not.
Yes.
Civil liabilities of the department in respect of their exercise of their public law functions, but which satisfy the folklore test or are in breach of the Constitution, or in English law terms would be misfeasance in public office. What happens to those liabilities?
Well, those liabilities we would accept would be liabilities of the Telecommunications Authority, right. And we say that the liabilities of the liabilities of the Telecommunications Authority under the 1988 Act are liabilities of the government, rather than the liabilities of the Telecommunications Authority as a distinct legal entity which can sue or be sued.
Right, but if the liability for a civil claim of the character that I've just been mentioning goes to the Telecommunications Authority, doesn't that indicate that it has legal personality in order to be the recipient of such a liability?
Well, I think one has to be careful, because there can be a liability. The question of whether there is liability is going to depend upon exactly what the cause of action is. If I would accept that,
I've put the causes of action.
No, my lord.
Okay.
If one accepts, I would have to accept that if there was a constitutional claim against the authority for damages, then yes, it would have liability for those purposes. We are talking here about liability for an ordinary civil claim in damages, and in our submission, the 1988 Act does not seek to set up the authority as the body that holds that liability.
Now, we're really going to have to hear from Mr. Chu Choi, and then you have a reply from the appellants.
You will, my lords.
Yep.
I will just give my lords the references where the Court of Appeal deals with the points of waiver and abuse of process. The Court of Appeal.
Well, you don't need to give us references to the judgment.
I'm very grateful, and our submission in relation to abuse, in a sentence, is this: if the court agrees with our submission that the legislature never intended the authority to have legal personality under the 1980 Act, and the legislature intended that the entity with legal responsibility, the government, should be immune from civil liability, and the claim was a nullity from the outset, it is plain that putting those arguments before the court in our respectful submission can't amount to an abuse of the court's process, because what we're inviting the court to do is to dismiss a claim which shouldn't have been brought in the first place. That's our submission. Thank you very much, my lords. Thank you.
Thank you, Mr. Vassal-Adams.
My lords, my ladies,
yes.
I'm perfectly content to speak from where I am.
I think
half a minute.
We can, in fact, hear you very clearly, but we also need to be picked up for our microphones for the recording, so I'm afraid you need to come forward. Well, it's refreshing to have counsel who is audible even without the microphone.
Well, I'll be very brief. You may wonder why I'm here on behalf of the Minister. And the short answer to that is, first, because the Ministry is identified as a respondent to both appeals, number one. And secondly, because when we read ground 8 of Emtel's grounds of appeal in the appeal against ICTA, we saw what I've quoted at page 3052, paragraph 5 of the Ministry's written case, which is that it is said the Court of Appeal judges had failed to address the logical conclusion that if indeed the authority had no legal personality, which Emtel denies, then the Ministry should have been held liable for its acts, doings and omissions, and should have been held liable in damages towards Emtel. And when we read that, it certainly wasn't clear to us whether this was being deployed essentially as an argument against ICTA, pure and simple, full stop, or whether it was being proposed to be argued on the appeal, on this appeal, that if for whatever reason Emtel failed against ICTA, then its fallback argument was going to be that the Ministry should be held liable by the board on this appeal. That's certainly how it struck us, at least as a possibility, which is why then we put in our written case. Since then, of course, as a result of the exchange of written cases, we've seen more clearly how Emtel has put its argument in relation to the so-called ground 8. And I think the formulation of the argument now appears at paragraph 138, subparagraph B of Emtel's argument at page 3020. 3020.
Thank you.
And again, to save time, because your lordships and your ladyships can no doubt look at that in your own time, but in a nutshell, what is being said by Emtel is that, well, had the lack of personality point been raised at an earlier stage than it actually was at the trial at first instance, then one alternative that would have been open to Emtel would have been to argue that, well, if ICTA isn't liable as a distinct legal personality, then the Ministry should be liable or the government should be liable. And effectively, therefore, Emtel is saying they have been prejudiced by the timing of that argument, and that is part of their case on waiver, on abusive process and Henderson. Now, if that is the only extent to which some form of argument is being directed against the Ministry, then I can stop here, and I don't really have anything to say about that. It's simply part of Emtel's argument as to why it says it suffered prejudice. I could say...
Yes, well, we've not heard any argument that we should be finding the Ministry liable.
Quite so. And indeed, I ascertained from Mr. Moulan yesterday, just before he stood up, to make clear that that understanding was correct. And he did make that clear. And indeed, he didn't say anything orally directed against the Ministry as a potential defendant, as it were, to a claim being advanced for the first time on the appeal.
And that being as I understand it, the Ministry were successful in its defence at first instance. There was no appeal.
There was no appeal against that.
And it's just...
And that's remained the position ever since, until we were named as a respondent to the appeals,
yes, and
we saw ground 8. So that being the case, I really don't have anything further to say. I would love to be able to say more about lots of other aspects of the case, but I think my views are irrelevant for that purpose. So, subject to any questions the board may have, these are my submissions.
No, I don't think we have any questions for you, Mr. Chu Chong. Thank you very much.
Just to say, the 15 minutes is devoted to Mr. Moulan.
Thank you, Ms. Braley. Mr. Moulan. Now, you will need to speak up. Thank you.
I would like to start with the written arguments, the written submissions at the end of trial, and that appears at page 5552. I'm sorry, 5313. This is the case that Emtel advances at closing. And what does it say?
I think we're looking at, well, apparently the submissions of a plaintiff.
Yes, Emtel.
Yeah, okay.
At closing on the 17th of June 2016. And we say it is such a serious fault as to be a faute lourde. Simply to give some context to your lordships and ladyships, a faute lourde is a faute inexcusable. It's of such a gravity, of such seriousness, that it may not be pardoned. This is how it is said. And if your lordships would turn to their own judgments of the board in 2017, in the case of Sautramont, I don't have it here, just quoting it from memory, this is how it approached faute lourde. If I'm not wrong, in paragraph 22, says my learned junior, of that judgment. I'll make sure that it is sent to your lordships just to see what is meant by faute lourde. We've already dealt with the issue. But more importantly, section 22 of that judgment will also explain how in a contract, a clause of exclusion of liability, une clause d'irresponsabilité, is knocked off by a faute lourde. And the whole of the discussion of Lord Toulson centers on that point.
That appears to be common ground.
Yes, indeed. But I just want to make sure, as I said yesterday, whether or not this applies to public authorities is still a matter which is quite discussed, even in France today. But I just want to say, in civil law, between private parties, it is established. If you go to paragraph 250, we've explained the points we had as to why we thought this inaction was inexcusable. What's important is paragraph 251. In its arrêt of the 30th of November 2001, the Conseil d'État held that a French regulatory authority, the Commission bancaire, had committed a faute lourde in regulating a bank when the authority had noted that there was a regulatory issue. The authority had itself required the bank to increase its capital, but the authority had failed to impose more stringent terms and delays upon the directors of that bank. Des prescriptions plus fermes, more stringent conditions that would have been required in the circumstances. I will now ask you to turn to the judgment, paragraph 290.
290?
Yes, which is at page 2765. It is submitted on behalf of Emtel that the failure of the Telecommunication Authority to ensure compliance with license commissions amounts to faute lourde. In support of this submission, reference is made to a decision of the Conseil d'État on 30th November 2001. The Conseil d'État held that in the case of a bank facing difficulties, the French regulatory authority, in failing to impose more stringent terms and delays upon the directors of the bank that would have been required in the circumstances, had committed a faute lourde. And she goes on to cite the full arrêt. And I will just read the last part of the paragraph. Que ces carences sont constitutives d'une faute lourde de nature à engager la responsabilité de l'État. That those failings constitutes a faute lourde of a nature to engage the responsibility of the state. To my mind, there is no doubt that the context in which conditions 7A and B came into being put upon the TA a responsibility to ensure compliance with the condition that it had itself set. Instead, the TA completely discarded its responsibility, failed to administer des prescriptions plus fermes, and shown tolerance of the breach of the conditions. In these circumstances, it can only be concluded that it has committed a fault lourde. My Lord, the reason I address that point here is to answer the point which is being made that somehow the liability would have maybe transferred back to the state, but not to the ministry or somebody else. Now, the immunity section was never pleaded, and rightly so, because it is of no application. And I thank my Lord Briggs for answering the question that my Lady Sales put to me yesterday and I was unable to answer by saying that, in fact, it is the own regulatory inaction of the authority for which it is being sued. It is not being sued for what a licensee did. We sued the licensee, Mauritius Telecom, and Cellplus for their own fault, unfair competition. That is the tort. They were sued for unfair competition. The authority was sued for its inaction, not the actions of MT, not the actions of Cellplus. What the authority did itself. And therefore there can be no question that the Section 29 immunity would ever be raised. It was never raised until today, and rightly so, I submit, my lords and my ladies. Now, the next point is the issue of the logical conclusion. All parties were present at all times. Had we known this in due course, as you will see in 2011, the learned judge said Emtel must amend its claim to include the responsibility for the negligence of the préposé of the government, which we did. If we had known this case, had it been advanced in time, that we have a full defense, a complete defense, maybe we would have done so. And the person who was the legal person, the Ministry of Telecommunications, was there, would have been able to answer that case. And those two persons are represented by exactly the same lawyers over the course of 16 years, in fact earlier, since 1996. So over the course of 20 years, the same persons will represent both the ICT, well, the TA, the MTA, and the ICTA. It is only on the eve of trial that a new counsel comes in and raises other points. But this is never, ever put forward in the form which is now put forward before you. Never is it said that somehow the liability would have been extinguished ab initio. We only hear that for the first time at closing. It was way too late in our submission to raise that issue then. This is what we wanted to say. If I may simply bring you to what Sir Nicholas said at trial. I would wish you to turn with me to page 597. I will not read the whole of what Sir Nicholas said, but if you go to
Which page?
it is page 597, my lady.
This is the transcript of the, closing submissions.
Exactly. Line
Is
6.
this Emtel's closing submission?
Yeah, no, it was the Emtel submission, yes, my lord, in 2009.
Oh.
It's 2000.
At the interlocutory ruling, the interlocutory appeal, before the trial judge in 2009.
It says
Hold on,
2013.
Yes,
I apologize, sorry. The appeal in 2013, my apologies. Yes, indeed. Line 6, talking of Emtel. The third, line 2. In other words, arguments may have scope and nature, remedy properly to be deferred. The third point made by the Privy Council was that Emtel had explained that it had commenced the civil proceedings, and the court will readily understand the reason why in 2000 it had lost 2 applications for judicial review. It had no guarantee that it would win in front of the Privy Council if it was going to proceed against the private parties. It needed a civil action based on foot. And so it commenced the proceedings, but it never, by that force of conduct, intended to give up or transmogrify or transmute in any way the rights and remedies that it claimed against the public authorities. It was recognized, of course, that there would have to be a management issue of the litigation if it prevailed in the Privy Council. Now, because it explained that to the Privy Council, the Ministry and the authorities submitted to the court that they should refuse to grant permission, even if with Emtel and the Privy Council records that submissions on page 13 of its judgment, what it says summarizing the submission, since the TA has now made an important advance and Emtel has issued civil proceedings canvassing the same issues as was raised by its application for leave to seek judicial review, there was no useful purpose to be served by now granting leave. And he goes on to the end of the paragraph where Lord Bingham says that the judgment of the lower court proved a hurdle in the civil claim, and therefore it was right that we ought to obtain leave. And that is the important part. It was never a change of action. It was the same action which was continued all along. We were forced to election. And when you read the written case at page 1834, paragraph 44, line 7, in this case, a valid judicial review was commenced in good time and leave was granted. There is and can be no possible suggestion that any legitimate public interest of a public officer has been prejudiced in any degree whatsoever. The Ministry had 3 chances to persuade courts to refuse permission. It was fully aware of all the arguments against it and argued comprehensively in opposition to Emtel. The Supreme Court forcibly transmuted the judicial review into a civil claim. But this was simply a procedural way of continuing the permission granted by the Privy Council, as is clear from both the Privy Council judgment and from the Supreme Court judgment. And the end is important at line 20. There is, moreover, no conceivable rationale or policy which is supported or served by allowing the Ministry to invoke POPA, and we say here to invoke the ICTA to raise this new point, to defeat an otherwise valid action. To hold otherwise will be a triumph of form over substance, a profound denial of justice, and a suborning of the normal principles of judicial review, and will serve to enable the Ministry to invoke a complete immunity from suit, thereby thwarting the judgment of the Privy Council. And I simply wish to end by putting this question. Let us say a licensee had done something wrong in the period up to up to January 2000. Would the MTA not have been able to act against that licensee? Of course it would have been able to act, because the actions which had happened before came over to be its own actions, and it could proceed any action that the licensee had done before. This is why Section 29 cannot be given that narrow interpretation which is sought to be put into it today with that my learned friend is trying to put forward. I think, my lord, my ladies, those are my submissions.
You go ahead.
There was just one question that had puzzled me. At the end of their judgment, the Court of Appeals said the fair thing to do is to order a non-suit rather than dismiss. But then I read somewhere that actually Emtel asked for the action to be dismissed, and I wondered what was the reason for that, and how does that affect what happens as a result of the board's decision in either direction?
Yeah, thank you, my lady. My lady, that was the worst thing that could have ever happened to Emtel, the worst. Any court that wants to thwart someone after 20 years tells you, oh, I non-suit you, so you can start again. By what possibility was it open to Emtel to restart his case from scratch? I mean, simply to say, At the time of the event, Mr. Karimji was well advanced in age. By now, he's over his 80s. I mean, would one really think he'd be able to go on for 3 weeks as he was examined and cross-examined in the same manner? It was just impossible to restart that case anew. Now, in such a case, it was no election at all. It was simply telling us, oh, by the way, you start again. This is why we said, no, we have every single thing on record. Everything is there. If you believe you ought not to give judgment for us, then dismiss our claim. We don't want a non-suit. We will not start again proceedings. Because the non-suit would have involved us starting from scratch.
But it doesn't affect what happens to this case, never going back potentially to the Court of Appeal.
No, my lady, not anymore.
Right.
Having moved for a dismissal, the case is now dismissed for the same reasons, and because we say we are not going to introduce any further evidence, we are not going to restart the case at all, we stand or fall by the evidence we have adduced on record.
Yes. Yes, thank you, Mr. Moulin. Yes, Mr. Adams.
I appreciate I don't normally get a position to respond, but there's one very specific point on which I have expressed instructions to respond to a point that was first raised in reply, which is just to point out that we did in fact appeal on Fort Lord, just so that you know that these are part of the matters going back before the Court of Appeal. And on the question of liability with regard to good faith and bad faith, and the bundle references are EB 1904 and 1905, the relevant grounds of appeal being grounds 10, 11 and 17.
So that's one of the reserved matters.
Those are part of the reserved matters.
Yeah.
Yes. Yes. Well, thank you. Well, I sincerely hope we won't have this case back here in another 24 years. We will endeavour to give judgment as quickly as we can. We're grateful to counsel for their assistance. Court is adjourned.